Okay, so we are at week 4 in Constitutional Law J331 for this fall quarter, and the quarter is moving on pretty fast. So I'm going to go ahead and get started with the information that I want to share with you before I go over the PowerPoints. Okay. The details that I really want to remind you of: make sure that you use the rubrics for your discussion posts. Make sure you use them for following. Make sure you use them for your project. And when it comes to that peer week, we'll work something out. Your other information, your thesis, your guideline, everything that you need given to you. And here's where our recordings take place, as we didn't have one week 2 because of the problem I have with losing a family member. And so now we'll have, after today, week 6, week 8, and week 10. So let's go over to our announcements. Okay. So for this week, we're talking about protecting basic freedoms, chapters 6 and 7 of the text, and the lecture notes that are in your module. And then you're to participate in the discussion assignment, when aren't our rights absolute, and complete an initial post. And then I will respond, and then I will submit a post for you to reply to, since there is no other student in the class at this time. Then finally, remember your criminal law project thesis and outline. Again, I referred to the fact I sent you information, but there's some thesis and outline guidelines that are right here, and you could go over that and you'll be able to get that information there. And then your mid-quarter survey, which you really don't have to do because of the fact that you're the sole student in the class. But if you want, you can, but then I'll know exactly who's doing it. So the idea of mid-quarter surveys and surveys period are to be anonymous. And then that's it for the announcements for the week. I've already given you the story about what adversity to springboard success means in the open house. So I'm going to go and let's take a quick gander at the course calendar. Course calendar, of course, for the 23rd. That's where we are right now. This Monday was the 23rd. Yesterday, your initial post was due. Now is your live lecture. And then reply post is due Saturday. And again, as I said, by Friday, I will submit a post for you to reply to. And then your written assignment, which I told you, the thesis and outline. Okay, this is for your project. And then next week there won't be a lecture. And then you have you'll have 2 written assignments the week after that'll do on the 5th of November. One will be your midterm. So there will be a midterm, and so actually for the midterm there is no thesis or anything to be done. So what I'm going to do is take that all out. All right. Okay, so save it like that. So then, so your midterm will take place in week 5. And then, okay. So you'll be dealing with the Supreme Court case brief. Again, there's information on the home page about how to write your brief. So that'll be that, okay? So now let's go to our week 4 module. Again, you see the assignments that I've already gone over, but your discussion posts, and it tells you what to do regarding a First Amendment right and your thoughts and so forth, and then I will reply to those and then submit to you a post to reply to. And then your thesis and outline, and you're going to make sure that you submit your test, your thesis and outline based on the model under technical requirements from week 2. You can go back and look at that. And you want to refer to this model for your work this week. The thesis and outline, as you know, provides the backbone of all your work because it sets you up for your course project that's coming up, okay? Of course, so you know when that's due, that's both of these, this is due Sunday. All right, so now let's go back to the course lesson content. In this lesson content, we talk about the fact that there are our freedoms, our basic freedoms, speech, press, religion, assembly, and that these are labeled as often fundamental, and we want to make sure that you know these rights so that you can apply them in the context of the criminal justice system, protecting yourself and knowing that citizens have rights when they're incarcerated, whether it's a federal or state prison. And it says, however, there's a caution: basic and fundamental rights are not absolute. That's where people make mistakes. And so there are a lot of changes that are taking place. There are challenges to some of these rights. We're going to talk about some of those tonight. And the courts have decided to limit some of these rights. So we're going to talk about these rights, and as you continue in your study and research, you'll discover more and obtain more knowledge about them. So tonight we're going to talk about one of my favorite debatable topics at the present time, the issue of the Second Amendment. We have 2 chapters. I may not cover one second, but I'm going to make sure I cover that Second Amendment because there's a lot of debate about the quote, the right to bear arms as it applies to individual, state, and federal government. And so there's a whole lot of things taking place in light of the circumstances and situations that we live under now, where things are constantly out of hand because of guns. So let's hold on for that. Again, these are the assignments. These are your lecture notes that I won't go over, but these are things that you want to make sure that you look at and pay attention for the freedom of what, and what does it mean in these situations, and then the freedom to speak, and then the right to carry a gun, which is something, again, we're going to talk about the situation in just a few minutes. And so you're going to hold on. But I really like what it says here in these notes. It says, Equally unclear and equally more hotly debated, the Second Amendment, the right to bear arms, involves one, the national NRA, which is a powerful lobby, and makes it clear that citizens believe in the Second Amendment as an individual right. And then so the courts have ruled that this was a state right, the right of each state to keep and maintain militia, rather than an individual to maintain guns. Now, that's where the debate comes, and we're going to, again, elaborate on that in just a few. Further complicating the issue, federal rights entering the gun equation, and especially where the Second Amendment is one of the few that has not been incorporated and applied to the states through the 14th Amendment. Thus, this amendment applies only to a federal regulation and doesn't apply to state governments. And then states are allowed to regulate their firearms with their discretion without the Bill of Rights. And federal agencies, it says, are allowed to participate in local gun control under the number of the IC, what we call the Interstate Commerce Regulation, Article 1, Section 8, in dealing with various acts such as the Free Gun School Zone Act and so forth and so on. So anyway, we're gonna go into that right about now. Okay. So you got all your assignments for the week because there's not a lot. So let's get right into the hot topic, I call it. So the Second Amendment, one of the, we call it a hot potato right now because of the fact that it starts out by saying that a well-regulated militia, and see, a lot of people don't read that. They don't read that Second Amendment completely. And we understand that as professionals and people who interpret what the Constitution says, the language says, what is a militia then? So if we says it's a regulated militia, it is an armed group of citizens who are to defend their community as emergencies arrive. Now, that does not mean individuals grabbing guns. That does not mean individuals have a right to bear guns. It means, so what is an armed group of citizens defending their community? The Army, the Navy, the Air Force, the Marines, the National Guard, even I would say the police and other law enforcement agencies. But on the broader sense, that this to defend their community as emergencies arrive, I would say that can go very broadly to the military. And so, since we're talking about on a federal level, so what has happened here is that the controversy over the Second Amendment is whether people have individuals the right to bear arms rather than as part of militia. Well, reading this says in 1794 the militia was made up of free male citizens armed with muskets, bayonets, and rifles. Now the NRA is trying to eliminate that requirement or look at it. But the militia today goes right with what I said. The National Guard units in every state. Again, I can take it further and apply it to the armed forces. But the National Guard in every state certainly fits that criteria. And that's one of the things that they're required to do. Also, the United States Army, the United States has a standing army, which there is no need for widespread armed citizenry to take place. And again, that goes with my point. Once again, people have to understand and recognize the way that history affects how laws are interpreted. when you read something, one of the best things to do is ask yourself this. Number one, what did the author intend when they wrote this material? And oftentimes, you go back and you study the historical background of what was taking place around that time as to what that means. So the context that it goes forward, even to future years and future times, should not negate or eliminate the original intent of the parties. And that's where we run into a problem, is that in a vacuum, the language is read. I read my Bible. I study my Bible, and my Bible tells me a lot, but I study the language that it was originally written in, the Aramaic and the Greek, to get a clear understanding, because there's been translations of the Bible, but what I'm going to tell you is that the original language sometimes is misapplied after it's translated. So if you really want a clear understanding, you go back and you look at the author. If someone wants to know something about me, they can look at things they see, things that have happened with me, but the best source of information about me is me. So you can come to me. I can, as I heard a person one time say, I can do me better than anybody. So anyway, that's what this historical background information here is all about. Oh, this is some good stuff. I love this. I only get a chance to do this very often. So here's it changed. This is what happened. Modern-day militias in the United States consists of Ruby Ridge, the Branch Davidians, and Freeman. So these organizations show an increasing amount of heavily armed militia groups. Now, the Patriot movement conducts para-training and demonizes the federal government. Some of these groups are considered domestic terrorist threats. My point being is that they are not really the militia as intended in the United States Constitution. I've already told you who the militia was. But the modern-day militia, and the definition as some people are applying it, has created a very serious problem. So thus, people would rather go with something that's not true oftentimes, rather than to accept the fact that historically it was intended for the writing to mean one thing. So we have all of these different organizations that want to overthrow the government, basically, so to speak, and do their own thing. Some people feel that the government has too much power, and it says that individuals need to reclaim that power, often with the firearms they believe they're entitled to possess. Again, going back to what I said earlier, there are continuous arguments, and today I can tell you there are people who are on gun control side, and then there are people who are on what I call the NRA side. That's just put it the way it really is, or the right to bear arms situation. But let's look at what has happened. These mass shootings, Newtown, Columbine, Aurora, Tucson, Virginia Tech, and we can add now, as most recently in our time, Las Vegas, Nevada, and many places where gun control legislation needs to have taken place because of these mass shootings, but because of the two interpretations of the amendment, the question is, does the amendment guarantee individual rights to bear arms? And I say no, because I strictly construe the Constitution. I read the language, I look at the history, and I say the history supports my position. The history does not support individual rights to bear arms. And if you read many of the court cases, you will discover that that is the argument that's presented over and over and over again. But unfortunately, as the courts change, so do the interpretations change. The bad part about it is if the court, and I'm speaking from as a legal side when I was a lawyer, but I'm speaking more from the perspective of my degree in political science, that the separation of the different entities that we have in our government, the executive, legislative, and judicial, and in the landmark case of Marbury versus Madison, the courts determine what the law says. They have the final word on what the law says. And so my point being is this, is that if judges misapply, then what they're doing, and I've seen some Supreme Court justices say this, that we are misapplying the Constitution and we are becoming legislators on the bench. And that's a bad thing, because now we're crossing and mixing the check and balance roles of each of those different three sections of our government. Does it guarantee the states freedom from federal government infringement on this right? Well, again, that historically has been laid out already. The states have rights, but remember, people, that the U.S. Constitution is superior, and that because of the fact that the Second Amendment has not been incorporated to the 14th Amendment, which allows the Bill of Rights to apply to the states, there is a problem here. And that may need to be one of the issues that need to be fixed so that that takes place. But then there will be people in the states that say, no, 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 now you're overstepping and taking away the rights of the states. So the debate continues, and guess what? While the debate continues, so do the Columbines, the Aurora, the Tucsons, the Virginia Techs, and the Las Vegas, Nevada type situations take place continuously. Continuously in Orlando, Florida, same situation there. I can, the list goes on and on and on. And so the question is, how much longer are we going to go debate while lives are lost because of guns? It's a question. The phrasing clause of the Second Amendment into two parts is what has caused the biggest debate, and that's exactly what I recognize. The operative clause identifies an action to be taken or prohibited. The prefatory clause announces a purpose, but it does not necessarily restrict the operative clause. So the debate around the Second Amendment centers around the operative clause and the prefatory clause and the intentions of the founding father. And that's what I'm proposing, is that what did the founding fathers intend when they wrote this? And when you read it and then contextually, then you begin to get the point. But what people want to try to do is politicize what the amendment says, and that's where we have the problem, because it's so highly politicized between the gun control people and the NRA, or the right to bear arms people. So let's talk about this. Let's elaborate. Let's expand the whole discussion right now. The proponents of the right to bear arms endorse individual rights, saying that every citizen has a right to guns, to bear arms. That's what it says. That's what they're saying. They're saying the right to bear arms is intended for individual interpretation and guaranteed right to all citizens. All citizens. Now, let's stick with that for right now. The proponents of this position primarily see the rights of the people It's an individual right, not the government, not the states, the individual rights. In other words, it's almost like this. Put it to you like this, people. It's like saying you are born with the right to get a gun. That's really what it's saying. And so there are things that you are born and you have a right to. Well, you are born, as it says, to life, liberty, and the pursuit of happiness. That's something that you have a life entitled to, and we try to apply that in terms of having a law, but unfortunately it's not helping. It's not working. It's not working, people. We have a problem here. So what is happening here is that the rights of the people are pulling hard to take away control of firearms from the government. They also claim that the framers of the Constitution intended to preserve individual rights above state rights. Once again, that goes back to the point I was talking about earlier, that if the 14th Amendment was to apply to the Second Amendment in application to the states, that in essence would require that the states respect and apply the federal laws to every citizen in the state. The courts throughout history have consistently rejected the individual rights view in favor of the states' rights interpretation. So moving away, it appears that the individual rights position is proposed by, I call those who have a vested interest in citizens bearing arms. Who has that vested right? Who does the NRA represent really? Do they represent the individuals? Partially. But who is their ultimate client? Who do they represent for real? Just say it. The gun manufacturers. The people who make the guns. They're the ones who benefit firsthand from guns, from automatic, semi-automatic weapons, as shown by the fact that they have these big gun shows. It's all about the profits, people. And so as a result of that, the individual rights are used. In other words, those individuals are all pumped up. Yeah. But it's in favor of the manufacturers of the guns, because if the manufacturers of the guns don't have the individual rights, people, they don't have a market. People ain't gonna like that. There's a lot of people I know that won't like that, but it's still. I'm trying to express that we have to contextually, and I'm a big fan of context. People hear me all the time talking about, even in the Bible, hey, don't just take a verse, read the beginning, verse before, verse after, put it in the context so that it's clear, the timing and the situation. That's the same exact thing I'm saying with the Constitution. But because the economics seem to override the situation, and the politicians who allow the gun laws to be written in such a way, and then the courts come back and try to play middle of the road, as instead of being hard and fast the way they really should, and say the right to bear arms does not exist for individuals. It was not intended that way. That is not what the founding fathers intended, and therefore all of these things, the government. So then people turn around and use the fears of saying, oh, criminals, they have guns, why shouldn't we? Criminals violate the law. So you're saying then, in other words, that we should also be allowed to violate the law without repercussions? Then we have anarchy and chaos in the country. So once again, I I'd love to sit on panels to debate this issue because I know what the Constitution intended. I know what the author intended. Not that I'm this great Karnak or somebody who, and some people might not know what that Karnak means. That's a mind reader back in Johnny Carson days. But the point of the matter is that I am based on my due diligence to do my research, to go back and see what does history tell me that should be taking place regarding guns. Okay. I told you I wasn't going to make it through the whole thing tonight because I know what happens when I get here. Okay, let's now look at, we talked about the individual rights. Now let's move forward in state rights. Now, to be honest with you, state rights is moving kind of in the direction that the Founding Fathers intended. However, it's still subject to manipulation. So those favoring the states' right interpretation say that the Second Amendment, as protecting and modifying Article 1, Section 8, the Commerce Clause, grants Congress the power to provide for the militia and to execute the laws of the Union. That's true. That's true because of the fact that it is through the Commerce Clause that the militia exists on the federal level, which is the military, Army, Air Force, Marines, Navy. And the states have their version called the National Guard. How come they don't call it States Guard? I asked somebody. And they just looked at me. But the point of the matter is because it goes back to what I just said a few minutes ago. The purpose of the amendment is obviously to assure the continuation and render possible the effectiveness of these forces on this level. The National Guard, the Army, the Air Force, Marines, and the Navy, those various military forces. And they're the ones who have the rights to bear arms according to a well-organized militia on the interpretation as the Founding Fathers who established in the Constitution in the Bill of Rights, Second Amendment. So the state rights proponents claim that the Second Amendment was adopted with the primary purpose of preserving the state militia. And that's where the debate comes in. And I was saying that now, so what happens is the state rights people want to use that against the federal and say that the federal government. But we have an old thing in the law business called the smoking gun. And then in the political side, we have a thing called the red herring. Well, the smoking gun is the thing that is the real deal. The red herring is the thing that's taking you off into other areas to cover up what's really happening. I would suggest to people today that all this media attention given to what's happening in government, with the issues that's happening with the president and some of the stuff that the media is engaged in and some other things is kind of a red herring type thing to take you off of the real issue that is taking place. And sometimes people go for that, or we say take the bait or drink the Kool-Aid. The courts have consistently interpreted the Second Amendment as allowing states to regulate private gun ownership. The states to regulate private gun ownership. And so once again, keep in mind that it is in the vacuum that if they were to apply what the Second Amendment says in itself, they would take the position that some of the municipalities have tried to do, like Chicago, D.C., where they have said no guns, zero guns. The people who had guns were that were citizens outside of the police and the military people or the National Guard were people who were like security guards who were using it only though for the purposes of a tool during the time they were working. But after that, they went back to putting those guns away. But what has happened in this country? Getting a little ahead of myself, but We'll come to that. But the amendment preserves the state power to defend against foreign and domestic enemies. Foreign and domestic enemies. And it also reduces the need for a large standing army. Now, that's the argument in a nutshell. But to be honest with you, we need both tiers. Both tiers perform certain roles. Just like, for example, to be honest with you, if you're a police officer and you're a police officer in a certain city, that you generally don't have the rights to perform your police duties outside of that city, unless they're granted in special situations. Maybe you're assigned to a special unit somewhere else or something like that. The point of the matter is that so the National Guard in Illinois is responsible for Illinois unless they're dispatched to Indiana, Michigan, Wisconsin, Iowa, Missouri, just to name the states that are around Illinois. But any state in the country, such as they could have gone to Vegas, they could have gone any place where there's mass looting or anything take place. The bottom line is that this statement to preserve the state powers and reduce the need for a large standing army is not accurate. It's not true, and it doesn't work very well in reality. We have to remember that the law is based upon paper, but how it operates is not based on paper. It's based upon people and lives. So let's look at a case from 1875, the Crookshank case. I remember studying this in constitutional law when I was in college back in '74, yeah, around that time. So here's what happened. An armed group of whites killed over 100 black freedmen, and they were convicted under the federal law of conspiring to hinder the freedmen's right to bear arms. So, and so what happened is that there became the debate, can individuals be found guilty of infringing on civil rights? And the answer was no. The answer was no. However, the court said that the 14th Amendment prohibits a state, they were talking about government, from depriving any person of life, liberty, and property without due process of law, which meant you had a right to a hearing, confront your accusers, present evidence in your defense, and so forth. But this adds nothing to the rights of one citizen as against another. So Crookshank basically stood for the proposition that it requires government to violate the civil rights of individuals, not individuals. So when you kill somebody, generally commit murder in a jurisdiction, you're not violating them of their civil rights. The Constitution, you are depriving them of life. But the point of the matter is, as is applied, the application for what that means is based on what each state has said. And those of us who study criminal law know that there generally is, across most jurisdictions, the similar application as to how to treat a person who commits murder and takes the life of another person. But again, the proposition is that those individuals are not violating the civil rights of the individual. That's technical stuff. But those who violate the civil rights of individuals operating in law enforcement or in military or in some official government capacity, then in that case, then they are violating the civil rights of individuals, as cases have demonstrated. But here's the point in common. Does it really matter to me as if my loved one is killed by a police officer or an individual who commits a robbery and kills them? Sure, I look at the individual, but then the main thing is I still have lost my loved one, and that's lost in the shuffle oftentimes there, and people don't get that point. So anyway, that's what Crookshank stands for. Early case law regarding the Second Amendment had a slow start, The National Firearms Act of 1934 came about because the federal government wanted to regulate firearms. This was the first time that happened. So with the case of Miller versus United States versus Miller, a 1939 case, the district court granted Miller demurrer, which meant they allowed the individual to move forward, requested that a suit be dismissed because the facts don't sustain the claim against the individual. So the United States says, no, we're appealing this. So they did. Well, the Supreme Court, when it got to the Supreme Court in this 1939 decision, the Supreme Court recognized a state right rather than the individual right. So they said, no, it was incorrect for the district court to grant the demurrer. And so they said that the Supreme Court said that the states, rather than the individual rights to bear arms, is what's prevalent according to the Constitution. And this case indicates that the amendment protects only arms that bear some relationship to preserving a militia. Back to what I said a little earlier. The case law begins to support positions. Stevens versus United States, a appellate court case in Sixth Circuit in 1971, where the law prohibited possession of firearms by convicted felons. And then the question is, does this violate the Second Amendment of that citizen to right to bear arms, even though they're a felon? The court said that there was no express right of an individual right to bear arms. That's true. That is true. That's exactly what I said earlier, is that individual rights to bear arms, there is no express right. Now, what has happened, unfortunately, is that there are these implied rights that have evolved and overruled the express rights. In other words, instead of going by what is said, what is written, it's going by what people think and feel. But remember what I said earlier. The application of those things is dangerous because it allows someone to profit from that. And I told you, the ultimate parties who profit are not the NRA, they're the vehicle, but the manufacturers and makers of guns. The rationale in Miller, citing Miller as authority for this conclusion, the court undertook no analysis of Miller or the history and ratification of the Second Amendment. This case involved possession of firearms by a person who was a convicted felon, a class of person whose rights traditionally have been more restricted than law-abiding citizens. That's the reasoning behind that. But the point of the matter is that the court basically, instead of saying that, they said there's no express right of an individual to keep and bear arms. So after the Miller case, many cases, 30 or more than 30 cases involving the Second Amendment, and they keep coming. In every case except one, the courts have held that the amendment refers to the right to keep and bear arms only in connection with a state militia. I already said that. I have no problems with the state militia part. Some people want to make it federal, but I mean, I understand. But again, if you applied the 14th Amendment to that, then you might have an individual rights situation. But the fact of the matter is that the case is the whole Second Amendment is misapplied. U.S. versus Emerson. A district court went against all federal court precedent in 1999, claimed that the Second Amendment guaranteed the right to individuals to keep and bear arms. 1999. And here's what's happening in Emerson. they went a whole nother direction. And you have to read the whole case. I have not, but it would tell you the answers to why they did. But we know as interpreters of case law that we have a system called stare decisis. Stare decisis means we apply the decisions of the previous to continue with the decisions of future cases, unless it is demonstrated a very good reason for changing that, such as what happened with Plessy versus Ferguson, which said separate but equal was good. And then the Supreme Court, led by Justice Thurgood Marshall when he was an attorney, I think it was 1954, in the case of Brown versus the Board of Education, said separate but equal is not adequate and should not be the law of the land, and the law of the land changed from there. But there was a good reason, because the people were being stifled unfairly if you were a minority. In that case, particularly if you were a black, or in that term, during that era, if you were a colored person, or Negro, as it was used, but it was colored person that we were talking about. So then the court says, no, your race should not dictate how you live your life in terms of housing, education, and the other issues that came along with it. So, but that was a good reason to change. But here in Emerson, the district court totally went against the precedent. Again, I argue and present, do some research, do your due diligence and find out what led them to do that. What is there someone behind the scenes that's pulling the strings? And I already told you, you'll trace it all the way back to the gun manufacturers. District of Columbia versus Heller. This is a 208 case, similar to the one we had in Chicago, where D.C., the District of Columbia, required residents to keep lawfully owned firearms unloaded and disassembled. So that meant that if they had a firearm, they really couldn't have it in a usable situation unless they fit the criteria of military law enforcement or had for some other justifiable reasons to use it based upon the law. So the issue is what rights are protected. So now we begin to look at the rights that are protected by the Second Amendment, and here we go, for people. We're going out into that deep. So the Supreme Court said that the Second Amendment protects an individual right to possess a firearm unconnected with the militia. First time ever it went to the U.S. Supreme Court, and they said that. And so the ruling has had little impact on federal gun control laws. But the fact of the matter is that it gives fire to the individual rights position, as it originally was not intended. So you see what we're doing. We're moving further away. You know what happens? There's an old thing that says when you start to move away from the truth, and you get so far away, after a while, you get so far away from you that you don't even think about going back to it to deal with what has to be dealt with. And so that's the scenario that we find taking place now. We are so far away, guys, from what the Founding Fathers intended that people don't even want to hear it. They don't want to hear it. You know, it reminds me of what I'm taught in terms of my Bible and my preaching as a minister, is that people don't always want to hear what the truth says in the Bible. They want their own interpretations and applications of it, and so therefore they say, no, this is what it means for us at this time. And that's where we run into a problem, because it was all good the way it was originally written. I'm talking about the Bible, and the Constitution was all good the way it was written regarding handguns and regarding guns, period. But again, the political forces and the economic forces have intervened to change that. incorporation of the Second Amendment. The Second Amendment remains unincorporated until 2010. And here's the Chicago case I was talking to you about. McDonald versus Chicago. The city of Chicago banned almost all handgun possession. All. That was what they did. That was what the mayor proposed at that time. That was Mayor Daley back in those days. And that was Mayor Daley. I think it was Mayor Daley. I'm almost sure it was the second Mayor Daley. But anyway, this defendant, Mr. McDonald, argued that this left him vulnerable to criminals. Does that sound familiar? Yes. That's what people say today, to use that. Once again, it's pushing a button on people to still take them off of the main issue and what is going on. So the Supreme Court held that the 14th Amendment incorporates the Second Amendment right. Oh, buddy, in constitutional terms, it resulted in individual rights. Again, problematic. The right to keep and bear arms was among the fundamental rights necessary to our system or order of liberty. The Second Amendment applies to the states. That's what it said. But again, it's paving the way for individual rights in terms of bearing arms. And I tell you this, people, the ban in Chicago was awesome. Guess what? Don't we wish we had it now? They can't even get it back now because of the way that we've gotten so far away. Remember, I told you, further and further away from the original intention and truth. Variation in state and local gun laws. States retain the right to impose stricter regulations than those required by the federal government. And so what has happened is that the states then are allowed to come up with what we call concealed carry laws, the castle laws, restriction on types of firearms that they allow to be owned by citizens in the various states. And now what we've done is opened up a can of worms, where what people do is they go across state lines and they buy in states where that allow certain things. Carry conceal didn't exist in the entire United States until I believe it was 2013 or 14. One of those two, I think it was 13, no, that Illinois was the final state that held out. And then finally, carry concealed came in. Some jurisdictions now have open carry, which means you walk around like the Wild West with guns strapped on your hips and shoulders. You don't even have to cover it up. So we got into a problem. But remember, a case like McDonald opened up all of that. So come to the Lopez case, the United States versus Lopez, a 1995 case, which involves school zones. Gun-Free School Zones Act, or GFSZA, made it unlawful to carry, possess a firearm in a place where education was taking place. In this case, it was, I think it was a high school, but Alfonso Lopez Jr., defendant, a 12th grade student carried and concealed a loaded handgun into the high school and was arrested. So the question is, does that exceed Congress's authority over the Commerce Clause? In other words, did they reach too far? The Supreme Court struck down that law, struck down gun-free school zones. The reason they said is because the possession of a gun in a local school zone is in no sense an economic activity that might, through repetition elsewhere, have a substantial effect on interstate commerce. But the point of the matter is that why was that law in place? It was for the protection of individuals. Now, you and I both know now that you can't, possess a gun unless you're a law enforcement person in schools and, like for example, at our college at Rasmussen, you'll see signs on the door that says you can't. And so we have law enforcement people on that have classes on the campus, and they understand that they're not allowed to have their weapons unless they're on an official call, an official duty. The point of the matter is that you have to ask, what are you trying to do with the law? Are you trying to protect people? Well, what has happened is that lives are sacrificed for the financial gain in other organizations or individuals, and that's what ends up happening. That's the reality of it. Restrictions on types of firearms. Some weapons, such as fully automatic machine guns, or those altered to be more conductive, but it's conducive to criminal activities such as sawed-off shotguns, which I remember in my day when I was younger, have always been illegal for most people to own. What exactly constitutes a weapon or firearm has not been easily defined. That sounds crazy, but that's the argument. So fully automatic guns. What about semi-automatic guns? What about guns like the one that were used in the killing in Vegas recently? They say, well, that wasn't a fully automatic. You tell that to the people that were killed with rapid fire or shower rapid fire. They don't care if it's semi or fully. They know that it was a weapon that, whether it was converted or whatever, the fact of the matter is that it was used to take their lives. Federal regulation and the Second Amendment. Congress uses its broad authority to regulate interstate commerce and enacted some federal gun control legislation. In 1938, Federal Firearms Act required dealers shipping firearms across state lines and importers to be licensed by the federal government. In 1967, the Omnibus Crime Control and Streets Act, which made possession of firearms by convicted felons unlawful. In 1968, the Gun Control Act banned federal licensees from selling firearms to prohibited persons, those under indictment for convicted of a felony, a fugitive, a drug user, those kind of things. So the point of the matter is that what's these all about? These are movements to try to reduce firearms. But remember, what happens is that the power and authority of money begins to utilize some of these court cases to benefit them and to ignore the intention of what the founding fathers intended when they crafted the Second Amendment. The Brady Act, this was one that came because of some violence. So those, by way of history, Brady was I think he was the secretary, or anyway, he was one of the parties who worked with President Reagan, and President Reagan was shot at, and but Brady was wounded, and there was also a Secret Service guy who McCarthy, out in he was the chief of police for many years in Orland Park, Illinois here. But anyway, President Clinton signed the Brady Handgun Violence Prevention Act in 1993 after this incident happened, contained the interim provision of a mandatory 5-day waiting period, so that we can find out why this person is getting these guns, what's something about them, do some background checks and stuff like that. This provision was phased out in 1998 with the permanent provision of an criminal background check on all handgun purchases except those made at gun shows. See, I told you already, back to those gun shows. you will discover that if you check the person that possessed those weapons in Vegas, gun shows is where it happened. But once again, it gets back to the money, the money. Some states still impose a waiting period on firearms purchases. And it makes sense to have a waiting period. I mean, since we already have lost out on controlling the guns per se, then at least to try to delay putting it in the hands so you find out more information is beneficial to the lives of the average person. In Prince versus the United States, the Brady handgun violence prevention law required local chief law enforcement officers to perform background checks. Using the necessary and proper clause of Article 1 of the Constitution, Congress can temporarily require chief law enforcement officers to regulate handgun purchases by performing those duties called background checks. So the Supreme Court held that the federal government was not empowered to require state or local government agencies to run background checks because they said that states had the right to do that themselves. According to the court, the background check provision violated the principle of separate state and sovereignty. Again, the clash between federal and state law. But anyway, once again, the question is, what are they trying to do with these laws? We already gone over that. The Violent Crime Control and Law Enforcement Act of 1994 banned the manufacture of 19 different semi-automatic, banned the manufacture of semi-automatic guns with multiple assault weapon features, prohibits the transfer to or possession of handguns by juveniles and ammunition, prohibits the possession of firearms by people who have committed domestic abuse. Big move towards trying to get guns out of people's hands. It provides stiffer penalties for criminals who use firearms to commit federal crimes. This ban expired with what we call the sunset clause, which means that the time ended for the legislation and it was not renewed. So it went away. It didn't have to die because, of course, it was inaction that caused that, or as I call it, negligence. The Law Enforcement Officers Safety Act allows qualified off-duty and retired police officers to continue with their weapons, and the goal is to establish equality between law enforcement officers, and it says to create an unpaid homeland security force to help protect the nation. And so anyway, law enforcement officers are allowed to keep their weapons and carry their weapons as long as they can establish that they were law enforcement officers and left under good terms or retired or those kinds of situations. Other proposed federal legislation recently denying firearms explosive to dangerous terrorist acts because we're in that age now. Those on the terrorist watch list. Gun Show Background Check Act require vendors at gun shows to hold a federal firearms license and to conduct background checks. And then assault ban weapons. Would have reinstated the 1994 controls, but was dropped, so it didn't really get off the ground. So, the end here. The current debate, and then I think we got about a couple more, and then we're done. In opposition to gun control, the common argument about gun control is the claim that such laws will put guns where they don't belong in criminals' hands. That does not make sense. You're going to tell me that the laws taken out of the citizens' hands puts it only in the hands of criminals? The law doesn't put that in there. No more than the law gives carte blanche to citizens to commit murder or robbery or any of those things. The Founding Fathers wrote the Second Amendment to protect citizens' rights to defend themselves against oppression. And that's the debate. When people are disarmed, government, tyranny, and oppression thrive. Oh, gee. Again, I laugh at it. It's sad, but it's also funny because you know what, people, in my career, I've been able to learn from my obtaining my political science degree to my law degree, and then my experience of working out here in various capacities as an attorney, and now as an educator. And I think I have a responsibility to point us back to what was intended. And a lot of people says they don't want to hear us. They don't like us. Well, that's okay. Truth is still truth, regardless of whether you like it. It's not, truth does not have to stand based on whether or not you like it or not. It is all by itself able to stand. In support of gun control, the Fraternal Order of Police, FOP, refers to this issue as crime control, not gun control. They support regulations consistent with the laws, but they do not support any new firearms legislation. So it's like straddling the fence type thing. Again, I told you what the bottom line is. The U.S. Constitution is proof that individuals have the right to own firearms. However, court cases, rulings don't grant individuals the right. So, again, is it really making any difference that the courts say no and the powers that be outside of the courts overrule them? It's supposed to be the other way around. Background checks for all gun purchases, including those at gun shows from unlicensed dealers, is a reasonable way to keep weapons out of the hands of criminals. I agree. But not the people from the NRA, not the manufacturers of guns. Gun control is also a way to control violence. I absolutely emphatically, this is a neon sign flashing, warning, a clarion call, a common sense statement. Gun control is a way to control violence. Yes, period. In support of gun control, history shows that the Second Amendment was written to protect colonists from England's King George III's military forces and contains nothing that could be construed as prohibiting gun control. Guns are not the root cause of violence, but their usage increases the lethality of violence. Yeah, well, limited purchases of assault weapons and semi-automatic handguns with high-capacity magazines used in many mass shootings, like most recently in Las Vegas, has a small impact on individual rights, but large impact on public safety. I agree. We balance that test. Give up some, just like the Patriot Act, you give up some individual rights for your overall protection. It's like letting my kids do whatever they want to do. But if I think it's dangerous, and since I'm the parent, they're not doing it. And if they do it above me, there's a consequence. That's the same thing that we're talking about here with these guns. There's a consequence. Lives are being lost. Finding common ground. Is there a possible compromise? Gun control by states is not constitutionally prohibited. Legislation by the federal government is not prohibited. It looks like the courts will continue to defer to the discretion of the states. This is the ending. It puts us in a position where the issues that need to be dealt with need to be dealt with. We have a saying in a church and how we do things that we seek to return to the old landmark. What that means, people, is that we want to return back to what the authors intended. In other words, in that instance, the Bible, what was intended by the authors of the Bible. And the same thing has to take place with this issue about Second Amendment. we need to return back to the old landmark, what was intended, and read the language once again. And so that's all I have to say about that. The Fourth Amendment, I'm not going to have a chance to deal with. That involves a lot of search and seizure and stuff like that. So if you have any questions, you can contact me regarding that. And so I am going to go back to the classroom. And then it's 7:41. I'm going to terminate this session. Hope to see you in the lecture in week 6.